Yeah. How you doing?
All rise, court's now in session. The Honorable John Murphy.
We're good.
Presiding.
Jury's here.
Hold on a minute back. I of all people should
Nice. No key. Good morning, guys and gals. Here's Miss Smith. She's around. She here?
She's outside of the next
You want me to record?
She just walked out.
The weather conditions are
Perfect.
perfect. I don't know if I should give the court credit or Gary credit.
Gary, not me.
This is the rest of it.
We have some mention to you, for those videos. Do you have an objection to that?
That's it now.
Yes.
No objection. Defer to the court, of course.
Here, the next witness.
We don't have court reporter.
Oh, yes. It's just on scheduling in terms of we're going to call the witness out of turn because she's a record custodian and we'll get her out here.
Does that mean you're asking Sergeant Williams
Yeah, we can
to
just
step down? I want you to wait a minute.
That's a nice way of saying get out of here. You should do that.
Not too far, though, not too far.
Could read it. I mean, it was.
Is there any paperwork for probation? Any paperwork for probation?
Let me ask you.
Okay.
Not yet. present is the defendant, his counsel, the assistant state attorneys. I understand the ladies and gentlemen, jury are ready to proceed. State ready?
Yes, sir.
Defense?
Yes, sir.
And it was made clear to me a few minutes ago that the state's next witness is going to be called out of turn. There's no objection, is that right?
No objection, Your Honor.
All right, so let's do that. Bring in the jury. Pardon me?
81.
Jury entering. That bad. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the jury, the defendant, defense counsel, and state attorneys. Ladies and gentlemen, I trust you had a nice night, and we're ready to begin now. The state indicated that they wanted to call a witness out of turn. Sergeant Williams is here, but he's just waiting outside. There's a short witness the state wanted to put on now out of turn. The defense indicated they had no objection to that. So we're going to call that witness first. Who is the witness?
Sean Newman.
Good morning. Are you Ms. Sean?
Yes.
Welcome. What I'd like to do is just remain standing, raise your right hand, and be sworn.
Do you solemnly swear or affirm the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Sean Newman.
Please spell your first and last name for the court reporter.
First name is Tashaun. Last name Newman.
Thank you. Please have a seat.
I want the record to
Ms. Newman, there's a microphone in front of you. It's pointing straight up, but you can move it down. All right? Just that way. All set?
Yes, sir.
Thank you. Counsel, you may proceed.
Thank you, Your Honor. Good morning.
Good morning.
Can you state your name and where you're currently employed?
My name is Tashaun Newman, and I work for the Florida Department of Transportation Turnpike Enterprise.
Okay, and what is your role or your assignment currently?
I am the account research manager. I oversee the department that does extensive research into accounts, as well as we fulfill public records requests.
Okay, and prior to your position as an account research manager, what was your position?
Financial investigator.
And what were your duties as a financial investigator?
A large portion of that position was fulfilling public records for law enforcement as well as for our legal department.
Okay, and in this particular case, back on or about October of 2018, did you receive a subpoena, not you specifically, but the corporation, receive a subpoena regarding video surveillance from October 26th of 2018?
Yes, they do.
And in the form of legal service, correct?
Correct.
Either subpoena or public records?
Yes, ma'am.
And did you fulfill that request?
Yes, I did.
And are video surveillance kept in the normal course of business by your department?
Yes, they are.
And are they essentially made out of near the time of the event, here specifically October 26th of 2018, and routinely kept?
Yes, ma'am.
Your Honor, at this time, I will be showing defense counsel to mark this case probable theft for identification purposes. May I approach the witness?
Yes.
And Ms. Newman, did you have an opportunity prior to your testimony to review the USB?
Yes, I did.
And what is it?
It's a USB with various videos of the toll roads on the express lanes.
from October 26th of 2018?
Yes, ma'am.
Is it in the same or substantially the same condition as when you last reviewed it?
Yes, it is.
Any alterations or deletions that you can see?
No, ma'am.
Your Honor, at this time, the state will view this evidence states quadruple F, that states 81.
Is there any objection?
No, sir.
Thank you. It'll be admitted.
States quadruple F, A mark states 81.
No request to publish at this time, Your Honor. No further questions?
Counsel, is there any cross-examination of this witness?
I have none, Your Honor.
Thank you, madam. Thank you very much. You may step down.
Thank you.
You're excused. Who is your next witness? We're back on with Sergeant Williams.
Yes,
You ask Sergeant Williams to come in, please?
Yes, sir.
That's interruption. It'll be a minute, ladies and gentlemen. Along with the defendant, anything to discuss? No? You need a restroom break, Mr. Dennis?
No, sir.
All right, we're in recess. Thank you.
It's always happening.
gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our defendant, Mr. Demmons, his counsel, the assistant state attorneys, ladies and gentlemen of the jury, and our witness, Christopher Williams, Sergeant Williams, remains on the stand. Sergeant, I just remind you, you still remain under oath, all right? And I think we're in the middle of your cross-examination.
Yes, I have nothing more for Sergeant Williams. Thank you.
No further questions. All right. Is there any redirect?
Yes, Your Honor. Good morning, Sergeant. How are you?
Good morning, Ms. Harlan.
So with regards to the autopsy photos and things that you reviewed, how were you able to get the approximate shoulder width of Mr. Thomas?
So the medical examiner's office, they use a scale it's a big ruler that goes the length of the autopsy table where the decedent is lying.
Okay. In terms of that, so you got that 2 feet 6 inches from approximately?
Approximately.
Okay. In terms of, counsel asked you with regards to the multiple times as to how did you rule out that someone was outside the car? Why? Why did you do that?
And that was explained in them also multiple times. It's the blood that was on the headliner, the lack of blood in the passenger side rear seat, and the GSR that was inside the vehicle.
Okay. With regards to ejection pattern testing that counsel asked you about, if you're going to do an ejection pattern, what would you have to do?
You'd have to have the firearm, and you'd have to have the ammunition to conduct that test.
And in terms of the time frame on the casings, is it important to find them immediately after?
It would be very important to find them immediately after.
So a month delay in finding them. Could you do ejection pattern testing if it's a month later?
You can, well, if you have the firearm, you can do ejection pattern testing. How it would apply to on the side of the road, you would have to do that on the side of the road with that firearm.
And if individuals have gone back and picked up casings from the scene, how would that affect ejection pattern recreation?
Individuals as in strangers?
4 people that were friends with the defendant. They went back to the side of the road.
Objection, Your Honor.
Sustained.
If individuals went and picked up casings, not knowing they were involved.
Objection. There's no evidence of that.
As to that question is overruled, the objection is overruled.
So if they were picked up, it could alter it, but at the end of the day, it still needs to be measured.
So in terms of the shots that are in this vehicle, how can you tell the approximate distance that the shots were fired from?
The approximate distance is obviously going, as I said, this is a unique case where our shooting is contained to a vehicle. So we have known distances within the vehicle, we have known distances of the, not necessarily the arm, but we have a known distance of inside of the width of people, and the stippling pattern that is on Christopher Thomas, who's on the back seat, and some of the stippling that is observed on Anthony Williams, who was in the front seat.
What about on the outside of the car? How can you tell that that wasn't shot from a mile away?
You can tell that it wasn't shot from a mile away by the angle of it and its type of impact into the vehicle. So if it's shot from a mile away, the projectile is going to start tumbling again. It's going to go head over heel. As it loses velocity, as it loses its spin, it's going to start wobbling, and then eventually will start going its head over heel and then keyhole into its target.
Did you see any evidence of distant fire in this case?
No.
In terms of the defendant in this case, you said you measured him?
Yes.
Do you recall about what date that occurred on?
Can I repeat?
If you need to refresh your recollection, please do.
November 30th of 2021.
And at the time that you measured him, was it here in the courthouse?
Yes.
And that's where your office was at the time?
Yes.
And could you describe his build?
He's slender, but he's tall but slender.
Okay. And in terms of, would you say that he has broad shoulders?
No.
And you said he was 5'6", right?
Correct.
In terms of that car that we were talked about, what's the best way to get an idea of how big the inside of that car is?
You can measure it, or you can also view it.
And where is that car right now?
That car is in the crime scene unit forensic processing garage right now.
Is it available for the jury to view this morning?
Yes.
Here, if we may approach.
Thank you, sir.
Thank you.
Madam State, who's the next witness?
Judge, we're just requesting a 5-minute recess to set up some videos for the review.
All right, ladies and gentlemen, take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Concerning no research. the record reflect the jury stepped out. We'll be in recess.
Pushed it up and I managed to get out and it kicks in my traveling salesman. That's a little bit. Is that way else is like? I said no. I said, so what happened? He's like. I said, somebody been with me. 2 weeks ago, the house caught on fire. We were all sound asleep. Kid went through there, blink. Woke everybody up. My whole family got out safely and saved all of our lives. Traveling salesman, that's amazing. But how much it costs, right? Yeah, I think so. Come on, man.
Yeah, I mean, no, not really. You are a GE.
Well, you have like, honestly, they don't go
Tell me?
There's rain hacker. They practice a lot.
I don't know if she's looking at her, but be here.
You all set, defense?
Yes, sir.
All right, spring injury. you doing, guy? Jerry entering. Thank you. Let the record reflect the presence of the defendant, Mr. Demmons, his counsel, the assistant state attorneys, ladies and gentlemen of the jury. Ladies and gentlemen, I think their state's ready to publish. Is that correct, counsel?
Yes, Your Honor.
What exhibit number is this again?
State's publishing states 81.
81 in evidence.
Yes.
Give the license, please.
For record purposes, I'm going to begin with I-595, eastbound and westbound express, 1026-18, 0320 through 435. Eastbound lanes. 2nd. And now published I-75, Miramar northbound, 1026, 18, 320 through 335, beginning at 337 a.m.
Yeah, nothing really happening. I mean, it's hard to tell what we're seeing here. Nothing, no indication that we're seeing the car that was the crime scene car, the car that actually where the shooting took place. Maybe you guys are seeing it more than I am. But Jamie, let's go back to the conversation about the death penalty, because I was talking to Dr. John about it. What is your thoughts? We have 8-4. That's all that's necessary to vote in favor of death if the jury ultimately convicts Mr. Demmons.
So Florida is certainly one of the more prolific states when it comes to death penalty cases, especially when it comes to African American men. So I'm from Michigan. We haven't had the death penalty for more than 100 years, and I'm personally and philosophically opposed to it. But if I were to take that hat off and be objective, in Florida, my understanding is that it's really a case within a case. So this will not be the jury that determines the death penalty. It's my understanding there'll be a second jury impaneled. I could be wrong on that, but I do believe that is the process. And in order for that jury to make a determination that a death penalty is appropriate, they'll have to make a determination that the mitigating factors are available. And certainly murdering two of your friends over a gang situation would fulfill one of those factors. But there also has to be some empathy, I suppose, associated with the victims. And what I'm hearing is that the victims really don't have a lot of family in the courtroom, or to the extent they have been, they've been in and out. And that's the kind of evidence that will compel 8 people to determine that death is appropriate. And if there isn't any sort of background associated with these gentlemen, that could be a problem for the prosecutor as far as seeking death.
Yeah, I actually want to confirm that. We'll find out if it's a separate jury or the same jury. We'll get back to you on that one. And now it's interesting because you think all murders are terrible. How do you know which ones are qualified for the death penalty? But clearly, I think it's the gang aspect of it, the brutal nature of it, the multiple murders. You can see why it would rise to the level that the prosecution is moving forward with. Again, but you would need to convict him in order for this to happen. Now, let me ask you this, Doctor. We're seeing a case here where the prosecution doesn't have all the pieces of the puzzle. They don't have the murder weapon or weapons. There's a serious lack of DNA from the defendant. I mean, what was it, last week? We learned that his DNA wasn't on a ton of key pieces of evidence. It was on I believe, the door handle on the left-hand side. I don't know if that's that surprising. We know he was in the car. Do you think that that's going to give the jury pause?
See, here's my problem with the scientific evidence that gets presented nowadays, and it's always colored by.
that way. I don't have an opinion one way or another. But despite all the horrific evidence and despite conviction, they may still feel that the death penalty is not appropriate. Again, go back to the Parkland school shooting case. That he had pleaded guilty, so it was just a question of whether or not he was going to be sentenced to death. And that jury heard all the evidence, and it was horrific. One of the worst school shootings, mass shootings we've seen, and they still voted life in prison. So it's kind of unpredictable.
It is, and thank you for clarifying. It differs from state to state as far as the procedures associated with the death penalty and
publishing at 3:49:01. That's the end of State's Exhibit 81. Going to publish State 61.
Can we approach first? Sure, hold on, Council.
Yep.
Thank you. Let the record reflect the shut down. Council remain along with the defendant. So the videos, these are things that
media production, those already been entered into evidence. The extraction would be the next thing the state would be publishing, which would be the 300 photos that we had pulled out to show the defendant's home.
so let me see what's on the.
Sure. And I think we had already done some of these, but I'll start playing them.
Listening deep. Hey bro, don't be speaking on me, bro. I don't do that. You don't do that. Ben, I got you listening deep.
Thank you. So these videos are just to show ownership of the phone.
Ownership of the Snapchat account.
This is the most important shit here. Like, get right there, like, you know you come back.
That was the video we previously edited, Judge.
Before we tell me, all that extra shit, and like, they need the most important shit here. Right,
So stop for a second. Which ones are you saying are need a balancing 403 analysis?
Well, many of them are either way before this incident or way after. I don't know what the relevancy is.
She's explained to me she's trying to establish who owns the Snapchat account because there's a dispute as to ownership of the account. That's the way I understand it. Is that correct, madam?
Yes, right.
Could we just see that last video again for a second?
This one? That's highlighted?
Right,
I know on these videos before there was an objection and I took out firearms, and there's also one with
money and cash.
All right. Anything like this on any of these?
No.
Do you have anything on any of these?
The next one as well? They both?
This one?
Yes.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Do we know who Snapchat is based on what we just saw? Whether it was the other gentleman
or Mr.
What's the 403 analysis?
Well, the relevancy, the 401 analysis. Right?
I heard 403.
No,
All right, so
401.
relevance on past because they're trying to establish who owns the account.
Okay.
So the relevance objection's overruled. What's the 403 analysis?
Okay, I understand, Your Honor, that it is overruled, but I'd just like to actually make the argument, which is, if their purpose is to establish ownership because of who is depicted on the videos, that would be undercut if we're seeing other people depicted on the videos. That does, if the person on the video establishes who owns the account, then it might be the other person's account. So that just shows that the argument does not carry weight. As far as the 403 analysis...
You can argue that to the jury. You can argue that to the jury.
Okay, I want to put my relevancy argument on the record for the court to consider. As far as the prejudice is concerned, Your Honor, in each one of these, it depicts Mr. Demons in a what may be, and we've only seen it. One thing we want the court to do is see them all, not assume the balance of them is not going to contain information that may have a 403 objection. So we first want to see them all and not be ambushed and try to unring the bell after.
You haven't seen them?
We haven't seen the ones, we haven't had them identify the ones that they intend to play. I mean, if you download some social media with millions of items of information and then come in here and cherry pick some to show, we need to see what they intend to play so that we can have some basis to either interpose an objection or not.
That's what they call a motion in limine. You file a motion beforehand, say, Judge, we need some determination as to all of these videos, which ones they're using or something along those lines, so we're not sitting in here while the jury's sitting in the jury room saying, what are they doing out there?
The other reason for the rules of evidence and the need for authentication is before they admit it into evidence, at the time they establish its relevance. So this is the time for that. Not us asking, looking at 16 million items and saying, out of these, we are going to ask you to eliminate 14. The proponent of the evidence is the one that carries the burden of establishing the relevance of the evidence they propose to admit. And at that time, the relevancy or 403 objection becomes ripe because of what is ensued in the trial and what is left to be proven. And that is our position, Your Honor. And it seems that they only have maybe 8 more and they're a second apiece. I'm not quite sure what the prejudice would be to having them go through them so that the court can see what it is.
So it's clear for the record, Your Honor, that is all the videos on Snapchat. That's the entire production that was sent in. So we're not cherry picking in any way, shape, or form on this particular exhibit.
So how many are there?
There's 5 more, Judge? 17?
Could you go back to the one before that for a second?
No, Counsel, we're just going to go through it. We're going through all of these.
Okay.
Let's just get it done.
Last one. That's it.
Thank you.
So the one that we would have an objection to primarily is the one that they have 3 versions of towards the end with music lyrics in the background saying that "and will kill you." That we think is objection. It's not his voice, it's a song in the background.
Play it again. Thank you. What's the position of state?
That is sent to one of the witnesses and that it is a threat to them and also an admission to the incident we have here today. So I'm going to cross-reference in just a moment with...
What's the date on it? I'm sorry?
11/22/18.
And that was sent to, hold on. Two different individuals that then are in this responses that are showing on the screen now, Your Honor. That there is a message that was sent from the defendant. It was a reply. That was a post that he had put on November 22nd, 2018. Then through the 3 messages on items 5, 6, and 7 are responses indicating that Mr. Demmons had posted that specific message online and acknowledging it that they had seen it as one of his stories at that point.
Your Honor, the state just represented initially that they were putting on this evidence to establish the owner of the phone. We then recognized that to have been a pretext because now the state is claiming that the purpose for those highly prejudicial videos is to show that they were sent to a witness. When asked to prove that, the state is demonstrating that it was posted online and somebody responded to it, which is not what the state said. It doesn't show it's being sent to a witness, and it's not for the purpose of establishing its phone. That is his phone, and it contains lyrics that are prejudicial, and we object on 4 or 3 grounds.
Wish to say that?
Judge, we can always play it without the sound if that's what defense is concerned on, and it still shows that it is his.
You're saying, though, the messages reflect that there's a threat?
It does, Your Honor, and I think that is relevant, and based on the time frame of when it was posted after the homicides, that it is something that should go before the jury. But Your Honor, if Your Honor is going to make the balancing call on that with regards to if the audio portion is considered too inflammatory, the video portion can be played without any audio.
So what do you need the Snapchat account for?
So in terms of the information's already been identified as Melly, Montana, as belonging to the defendant. And if you go on down here, This particular message, which is authored by the defendant, sent to Ms. Hamilton, saying that the individual known as Port, also known as Portland, saved in the phone, which is this co-defendant Cortland Henry, says that he saved the life of Mr. Demmons, and he's coming everywhere with him because if the crackers come grab him, it's my fault.
What's the date?
That is November 9th of 2018. In addition, Your Honor, so here's the entire text of it. Make it easier to read. So in addition, Your Honor, the name, Melly Montana. In addition, the Melly Montana name links back to the Celebrate, which also helps show and support that the phone in state 64 belongs to the defendant.
Anything else?
With respect to the statement itself coming in, our position would be that there is no contextual reference of what it refers to. These people have known each other for a long time. Outside of that, if that is what they're using as the predicate for needing the Facebook account in evidence and the court deems it to be relevant, the state has offered to play it without prejudicial audio, and we think that would be an acceptable compromise.
Thank you. Anything else contained in this Snapchat that has that you're alleging as threats against witnesses? Because I haven't heard anything about a threat to a witness.
No other words.
Pardon me?
No other of those, no.
All right. So regarding what counsel is objecting to, the audio portion of those three Snapchats, I agree with it. On a 403 analysis, take it out. So how long did these run?
Those would take about 10 minutes, and then the state would be intending to publish the 300 photos that we previously identified and showed.
Show the counsel with 300 photos?
Yes, they were the ones that we previously shown. And so in terms of, to make it clear which ones are published for the record, we can put this in to explain the thumbnails and then identify them as by the image number on that, as opposed to putting the entire file name for each image in.
These are the extractions from
State 64.
which is
With his cell phone.
research. And this is for the purpose of establishing that.
It's his phone.
These are the ones that we look at.
You can look at all those if you want to look at them.
The actual photos themselves, you have those.
Well, as I told you before. So, for example, if the file type is stuff you have a special codec installed.
Okay. These are those, right?
Yes.
You indicated, I mean, there were phones that were showed to me the last time, and I indicated those had to come out. Talked about sexually compromising positions as well as guns. All those type of photos are out.
The photos that are there would be ones that show the defendant's face, either on FaceTime calls or anything of that nature. There's no firearms that were in the photos that I showed Your Honor. It's my recollection. The defense counsel's reviewing them again, and I can put them up on larger format if they need.
I mean, I saw basic things that counsel showed me, 2 pictures in particular, which I agreed with, and they were overly prejudicial, not probative of anything, and they should come out. So you're saying there's no pictures in this exhibit that discuss that, is that correct?
Correct, Your Honor. And I'll verify again.
Do we have some stickers for a second?
Sure.
Thank you very much.
Recess.
Thank you.
Mr. Evans, you need a restroom break?
Melly.
Do you? Yes? All right, can we arrange that, please? Mr. Melly. Yes, sir.
Putting on this evidence to establish the owner of the phone. We then recognize that to have been a pretext because now the state is claiming that the purpose for those highly prejudicial videos is to show that they were sent to a witness. When asked to prove that, the state is demonstrating that it was posted online and somebody responded to it, which is not what the state said. It doesn't show it's being sent to a witness, and it's not for the purpose of establishing its phone. That is his phone, and it contains lyrics that are prejudicial, and we object on 4 or 3 grounds.
Wish to say that?
Judge, we can always play it without the sound if that's what defense is concerned on, and it still shows that it is his.
You're saying, though, the messages reflect that there's a threat?
It does, Your Honor, and I think that is relevant, and based on the time frame of when it was posted after the homicides, that it is something that should go before the jury. But Your Honor, if Your Honor is going to make the balancing call on that with regards to if the audio portion is considered too inflammatory, the video portion can be played without any audio.
So what do you need the Snapchat account for?
So in terms of the information's already been identified as Melly, Montana, as belonging to the defendant. And if you go on down here, this particular message, which is authored by the defendant, sent to Ms. Hamilton, saying, that the individual known as Port, also known as Portland, saved in the phone, which is this co-defendant Cortland Henry, says that he saved the life of Mr. Demmons, and he's coming everywhere with him because if the crackers come grab him, it's my fault. That is November 9th of 2018. In addition, Your Honor, so here's the entire text of it. Make it easier to read. So in addition, Your Honor, the name, Melly, Montana. In addition, the Melly Montana name links back to the Celebrate, which also helps show and support that the phone in state 64 belongs to the defendant.
With respect to the statement itself coming in, our position would be that there is no contextual reference of what it refers to. These people have known each other for a long time. Outside of that, if that is what they're using as the predicate for needing the Facebook account in evidence and the court deems it to be relevant, the state has offered to play it without the prejudicial audio, and we think that would be an acceptable compromise.
Thank you. Anything else contained in the Snapchat that has that you're alleging as threats against witnesses? Because I haven't heard anything about a threat to a witness.
No other words.
Pardon me?
No other of those, no.
All right. So regarding what counsel is objecting to, the audio portion of those three Snapchats, I agree with it. 403 analysis, take it out. So how long did these run?
Those would take about 10 minutes, and then the state would be intending to publish the 300 photos that we previously identified and showed.
Show the counsel with 300 photos?
Yes, they were the ones that we'd previously shown. And so in terms of, to make it clear which ones are published for the record, you can put this in to explain the thumbnails and then identify them as by the image number on that, as opposed to putting the entire file name for each image in.
These are the extractions from
State 64.
which is
With his cell phone.
research. And this is for the purpose of establishing that.
His phone.
These are the ones that we okay.
You can look at all those if you want to look at them.
The actual photos themselves, you have those.
Well, as I told you before. So, for example, we have a special codec installed. Your Honor, to my recollection. The defense counsel's reviewing them again, and I can...
I don't know if the state has any objection. I thought they had no objection to removing those.
There's no objection to removing the firearms, that some of those were left in there. They were inadvertent on there. There was two that just wasn't clear that that's what it was until the defense counsel pointed it out. But as to the money and things like that, Your Honor, those are images that were taken on the phone. Sometimes there's 5, 6, 7, 8 shots of that particular outfit or whatever the issue may be on that, which shows that the individual has all of the photos, that it's not just the one that's posted to social media. So it's important to show that there are multiple takes to get the best one that's later posted to the social media websites.
Thanks. What's the objection regarding the money? Shots of the money?
It's not relevant.
For the same 403 grounds that the court introduced the subject of money earlier, which is to the extent that it might be off, I'm not quite sure what the court's thinking is, but it's to the extent that it might be off-putting to see somebody flaunting their means. We think it's unnecessary. Plus, there's an unnecessary, as far as the 403 balance is concerned. If the state's purpose is to establish the ownership of the phone and they're putting in 300 photos, if we take out 20 photos of marginal relevance and potential prejudice, I think the 403 balance clearly weighs in favor of exclusion. It's cumulative, and it's also cumulative and unnecessary. And what the court has in hand and is handing back are the hard copies. The reason why we're taking so much time and we're over there with the state is because there are some digital images that the state was unable to print, and as among those, there are fewer that we seek to exclude, but they would be for the same reason. And the state would have to, at some point, go and take those out of the digital image, which would be removing, it's either money or guns. And I think that's it.
And you're saying that the pictures related to the money are important because why?
Showing who is using the phone. There are multiple images of the defendant in terms of he'll be taking 30 and 40 photos on one day, but only one is posted to social media. This is to be able to make an argument later on to the ladies and gentlemen as a jury that this is the person who had that phone, who's using that phone, because there's only one, the best image that's selected, that's put on social media.
Also suggesting to me that there, in that array of photographs there, that the total photographs with cash is 20 or so approximately, where it's flaunting funds, and more than enough to establish the point that you're trying to establish.
So in addition to that, there's been no testimony that's real money. In terms of that, there is movie and prop money that's referenced in other places in the phone. For example, there are notes in the phone in which the defendant has a list, wish list of things where he says he needs fake money to do a video shoot on that. So I don't think there's any undue prejudice on that in saying that there's any sort of financial means.
Anything else?
No.
I don't think it's necessary, so sustain the objection.
Okay, so we'll go through and then create a new selection of those photos with defense, and that way we can get that forward to the ladies and gentlemen of the jury.
And how long is that going to take?
About 45 minutes.
So I'm going to bring the jury in now, send them to lunch, tell them to come back at 1:15. Did I give you enough time?
Yes, sir.
You know, before we do that, I'm of the impression, and I might be wrong, and I stand corrected if I am, that this concludes the evidence that the state has to present today, absent the court ruling that the jury can go and view the automobile. And we have been presented with a written motion that they have fashioned very quickly, nice and efficiently. We would want an opportunity to respond. And so we would object to the viewing of the vehicle today and if they're going to take 45 minutes of the jury's time to take out photos digitally, and that's all they're going to do when we come back and play them, we might as well conclude and pick this thing up on the 10th when we return. So that's just my suggestion, and it's predicated on a understanding of what the state has left to present.
Thank you. So what is it that you need to do to prepare for the motion to do a jury review, Council?
Well, look at some research, particularly with respect to the purpose for that the state has advanced, which is to demonstrate the dimensions of the inside of the cabin of the vehicle. If it is to do that, the jury going and viewing a vehicle with 5-year-old congealed blood in it, a total scene, we might very well be able to find a substitute automobile that is clean, that we can rent, that will serve the same purpose. So if the court is of the opinion that the state is entitled to have the jury examine the dimensions of the vehicle, they can do it in a clean vehicle where there's no prejudice. So we want an opportunity to go rent one so they could go and see it, opportunity to find one that is of exact dimensions so there be no prejudice, and proceed that way, and an opportunity to research whether or not under the circumstances they'd be entitled to do it at all.
In addition to that, Your Honor, we'd ask the court to review the Judge Siegel's order denying the state's motion for review by jury of the proposed scene on the grounds that there are numerous photographs. The exact language is, the state has ample evidence from which a jury can gain an understanding, and in this case, the place where the alleged shootings of the vehicle out of 27 occurred. And as such, the court, Judge Siegel, denied that jury. There are plenty of photographs of the Jeep. I think the state introduced somewhere in the area of about 40 to 50, possibly more, photographs of the Jeep. There's no need to do that, but if the court is considering it, we obviously need time to do a little research on it.
Hearing the state would suggest I asked defense counsel numerous times if they wanted to view the vehicle and be able to make an accurate determination of that. They've declined to do so on any prior occasion. The vehicle is downstairs. If Your Honor and defense wanted to look at it to understand that it is not gory or gruesome in any way at this point, there's no bright red blood stains or anything like that, I would suggest that that would be important for defense counsel and Your Honor to see before making any such determination.
Well, a couple things. Number one is that I wasn't aware that Judge Siegel already ruled on a motion for a jury review.
Not of the car. That was done with regards to transport the jurors to the scene to give them an understanding of the time and space from Fort Lauderdale to the edge of the Everglades. So that was a separate with regards to a jury in terms of transportation and things of that. So
you're suggesting what Mr. Adelson just represented to me had nothing to do with the jury view of the vehicle?
Correct.
That is correct. I said the scene. And if the court misunderstood me, I apologize if I didn't.
I didn't hear that. Regardless, counsel, I spoke with Mr. Tom Wolf, who advised me that you mentioned to him this morning about the jury view. He came to me, and then I got a call from Captain Tianga telling me that it would basically be impossible to do a jury view today, that if they were going to do it, they needed time and wherewithal to a secure area, because the jury view would, I presume, require the defendant to be there. They'd have to be unshackled. His counsel would have to be there. You'd be there. I'd be there. The jury would be there, and it would be. They'd have to secure the area and what was explained to me by Captain Tiang is that's not a secure area downstairs, and he is concerned about it. So he said it couldn't be done today, and if you went so far as to ask for a jury view of the scene from Judge Siegel, I would have thought you would file a motion pre-trial regarding seeing a jury view of this as well, and you didn't, and I would have thought you would figure that out before you say something to the jury that it can be done or would be done. You know, that's the way it was. The implication I got. I would just think you'd clear that with the court before you start telling the jury about it. In any event, so we're going to bring the jury in. I'm going to tell them to be back at 1:15, and you go ahead with your publishing. But according to what I've been told by BSO, a jury view isn't happening today. So we can talk about the motion. We can set it down for hearing next week or tomorrow, whatever you all want. You figure it out. We'll pick a day and we'll talk about it. But it's not going to happen today.
Understand.
All right, bring the jury in, please. Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, his counsel, the state attorney, ladies and gentlemen, jury. Ladies and gentlemen, I apologize. It's going to be quick. I'm not done with the attorneys. I need some more time with them, so we're going to break for lunch now. See everybody back at 1:15. Just remember, you can't discuss the case, all right? Leave your notepads on your chairs. No research. Don't form anything about the case. Don't allow anyone to discuss the case in your presence. See you back at 1:15. Thank you, ladies and gentlemen. Anything to discuss at this time, Counsel?
Defense counsel should remain so we can go over all the images so there's no issues.
All right? Yes, sir. Resolve that. Thank you.
Thank you.
See you back at 1:15. Have a good lunch.
Information and then come in here and cherry pick some to show, we need to see what they intend to play so that we can have some basis to either interpose an objection or not.
That's what they call a motion in limine. You file a motion beforehand and say, Judge, we need some determination as to all of these videos, which ones they're using or something along those lines, so we're not sitting in here while the jury's sitting in the jury room saying, what are they doing out there?
The other reason for the rules of evidence and the need for authentication is before they admit it into evidence, at the time they establish its relevance. So this is the time for that. Not us asking, looking at 16 million items and saying, out of these, we are going to ask you to eliminate 14. The proponent of the evidence is the one that carries the burden of establishing the relevance of the evidence they propose to admit. And at that time, the relevancy or 403 objection becomes ripe because of what is ensued in the trial and what is left to be proven. And that is our position, Your Honor. And it seems that they only have maybe 8 more and they're a second apiece. I'm not quite sure what the prejudice would be to having them go through them so that the court can see what it is.
So it's clear for the record, Your Honor, that is all the videos on Snapchat. That's the entire production that was sent in. So we're not cherry picking in any way, shape, or form on this particular exhibit.
So how many are there?
There's 5 more, Judge. So that was sent to 2 different individuals that then are these responses that are showing on the screen now, Your Honor. That there is a message that was sent from the defendant. It was a reply. That was a post that he had put on November 22nd, 2018. Then through the 3 messages on items 5, 6, and 7 are responses indicating that Mr. Demmons had posted that specific message online and acknowledging it that they had seen it as one of his stories at that point.
Your Honor, the state just represented initially that they were putting on this evidence to establish the owner of the phone. We then recognized that to have been a pretext because now the state is claiming that the purpose for those highly prejudicial videos is to show that they were sent to a witness. When asked to prove that, the state is demonstrating that it was posted online and somebody responded to it, which is not what the state said. It doesn't show it's being sent to a witness, and it's not for the purpose of establishing its phone. That is his phone, and it contains lyrics that are prejudicial, and we object on 4 or 3 grounds.
Wish to say that?
Judge, we can always play it without the sound if that's what defense is concerned on, and it still shows that it is his.
You're saying, though, the messages reflect that there's a threat?
It does, Your Honor, and I think that is relevant, and based on the time frame of when it was posted after the homicides, that it is something that should go before the jury. But Your Honor, if Your Honor is going to make the balancing call on that with regards to if the audio portion is considered too inflammatory, the video portion can be played without any audio.
So what do you need the Snapchat account for?
So in terms of the information that's already been identified as Melly, Montana, as belonging to the defendant. And if you go on down here, this particular message, which is authored by the defendant, sent to Ms. Hamilton, saying that the individual known as Port, also known as Portland, saved in the phone, which is this co-defendant Cortland Henry, says that he saved the life of Mr. Demmons, and he's coming everywhere with him because if the crackers come grab him, it's my fault. That is November 9th of 2018. In addition, the Melly Montana name links back to the Celebrate, which also helps show and support that the phone in date 64 belongs to the defendant.
With respect to the statement itself coming in, our position would be that there is no contextual reference of what it refers to. These people have known each other for a long time. Outside of that, if that is what they're using as the predicate for needing the Facebook account in evidence, and the court deems it to be relevant, the state has offered to play it without the prejudicial audio, and we think that would be an acceptable compromise.
Thank you. Anything else contained in this Snapchat that you're alleging is threats against witnesses? Because I haven't heard anything about a threat to a witness.
No other words.
Pardon me?
No other of those, no.
All right, so regarding what counsel is objecting to, the audio portion of those 3 Snapchats, I agree with it. On a 403 analysis, take it out. So how long did these run?
Those would take about 10 minutes, and then the state would be intending to publish the 300 photos that we previously identified and showed
Show
here.
the counsel 300 photos?
Yes, they were the ones that we previously shown. And so in terms of, to make it clear which ones are published for the record, we can put this in to explain the thumbnails and then identify them as by the image number on that, as opposed to putting...
Can you say your name and where you're currently employed?
My name is Tashawn Newman, and I work for the Florida Department of Transportation Turnpike Enterprise.
Okay, and what is your role or your assignment currently?
I am the account research manager. I oversee the department that does extensive research into accounts, as well as we fulfill public records requests.
Okay, and prior to your position as an account research manager, what was your position?
Financial investigator.
And what were your duties as a financial investigator?
A large portion of that position was fulfilling public records for law enforcement as well as for our legal department.
Okay, and in this particular case, back on or about October of 2018, did you receive a subpoena, not you specifically, but the corporation, receive a subpoena regarding video surveillance from October 26th of 2018?
Yes, they did.
And in the form of legal service, correct?
Correct.
Either subpoena or public records?
Yes, ma'am.
And did you fulfill that request?
Yes, I did.
And are video surveillance kept in the normal course of business by your department?
Yes, they are.
And are they essentially made out of near the time of the event, here specifically October 26th of 2018, and routinely kept?
Yes, ma'am.
Your Honor, at this time, I will be showing defense counsel to mark this case quadruple F for identification purposes. May I approach the witness?
Yes.
And Ms. Newman, did you have an opportunity prior to your testimony to review the USB?
Yes, I did.
And what is it?
It's a USB with various videos of the toll roads on the express lanes.
From October 26th of 2018?
Yes, ma'am.
Is it in the same or substantially the same condition as when you last reviewed it?
Yes, it is.
Any alterations or deletions that you can see?
No, ma'am.
Your Honor, at this time, the state will move this evidence states quadruple F, that states 81.
Is there any objection?
No, sir.
Thank you. It'll be admitted.
States quadruple F, mark states 81.
No request to publish at this time, Your Honor. No further questions.
All right, my stellar legal panel for today are back with me to discuss that. Criminal defense attorney Jeffrey Wolf and entertainment attorney Mitra Ahuri. And Mitra, I want to start with you this time. What was the importance of that testimony?
Rebecca.
Yes, Judge.
Counsel, all ready to proceed?
Yes, Your Honor.
Yes.
I think that one thing that we can address outside of the presence of the jury, the state would like to revisit the identification of the decedent, specifically Christopher Thomas. Your Honor had previously ruled that we could not, without proffering to you what we've done.
What? I'm sorry.
If you recall the arguments previously when the defense cited the case law, Your Honor was asking us what efforts we've made to utilize a non-family member for purposes of identification of decedents. So we have at this point subpoenaed multiple witnesses, including, for instance, Travion Glass, who's refused to come to testify. We've also subpoenaed Patrick Deloach, who we had unsuccessful service on. We've subpoenaed Frito Bang, whose legal name is Frederick Gibbons. He has refused to comply with subpoenas, and his attorney, Danica Davis, who had previously accepted service on his behalf, has now no longer accepted service on his behalf, so we're unable to bring him in. And there was an additional witness who we have not been able to serve, Jacoby Mills, we have not been able to serve. At this point, the state is re-arguing and we're requesting that the court allow us to use the family members as the only credible witnesses that the state has to identify the decedents. Today specifically, we could call Leandra Phillips, one for the purpose of identification, but also for other testimony that's relevant to the case.
Thank you.
Your Honor, we find it to be disingenuous to make the argument that witnesses that the state has been unable to contact for the last 3 years, and they know they have, to say, but we really have been trying while we've been in trial, as though those 4 people who they know to be unavailable are the people that comprise the universe of people that can identify the 2 decedents. That's clearly not the case. For there to be a good effort, a good faith effort to identify somebody who's not family member, they should maybe broaden their search to somebody that the family might know, maybe a very distant relative, something of that nature, as opposed to the 4 witnesses that they know that they have been unable to reach for 3 to 4 years. To now come and say, we're really still trying to reach them, Judge, is not passing the hurdle of good faith effort to find somebody other than a family member to testify. That is assuming that these are the only 4 people they know. And they already know that they can't find these people because they haven't been able to find them for 4 years. So to now come and say, we still can't find them, but we really have tried for the last 2 weeks, is not moving the ball an inch.
In addition to that, Your Honor,
yes.
In addition to that, Trevon Glass is scheduled for a deposition tomorrow. The state informed us just recently, during the lunch break, that they anticipate he'll be here for deposition. So it's a little immature for them to bring up premature. I'm immature. To bring that up now.
Counsel, have you discussed with your witnesses the possibility of identifying their family members?
Yes, Judge. In fact, that was the reason we sought out Trevon Glass after obtaining a new address. We specifically told him that we would only be calling him for the purpose of victim identification. He said even that he would not be willing to come and testify due to safety concerns. If Your Honor also recalls Ms. Bradley, when Felicia Holmes was on the stand, she indicated that although she had met the decedents, that she was unable to identify them and unwilling to do so. The case law doesn't require the state to search the universe to be able to make an identification. We're proffering to the court that based on the discovery, based on our review of the case, we have no other credible witnesses that can identify the decedents.
My question, though, is, and maybe I wasn't clear enough with my question. Have you talked to family members about when they, assuming they testify and they are able to identify their loved ones, that it's concerning about what type of emotion they show and reflect, and we're looking really for more like an analytical, not some type of emotional response?
Absolutely, Your Honor. I spoke with Ms. Phillips previously when we had first addressed this. I will remind her. In fact, Ms. Bradley proffered to the court that what we would do to minimize any sort of emotional response from the family members is that we would not even show them the photographs while they were on the stand. The photographs are actually already in evidence, so what I could do is just having already previously shown her outside the presence of the jury, I would ask her to identify the ME number associated with that photograph. And identify her son. And just for today's purposes, we would be only using Ms. Leandra Phillips.
Judge, number one, the rule was invoked. They never brought that to the court's attention to get permission to allow any witness to remain in the courtroom. If the court recalls, at the very beginning of this trial, we discussed Jamie King, the mother of our client. And the state said they were not going to call her and had no objection. But we brought it to the court's attention immediately because we wanted permission of the court because she was listed as a state witness at one period of time.
Now, I know they weren't going to call her because they gave us a Brady motion response indicating that she was under criminal investigation, which would indicate that she would invoke her Fifth Amendment privilege concerning this matter, or any matter. But we did bring it to the court's attention because of the rule, and now to hear that a witness has been sitting in this trial from day one, apparently.
Counsel, you think that's going to create the witness to fashion her testimony
I don't
in
know,
such a way?
I don't know. I'm not.
You took her deposition, I think?
Yes, we did take her deposition, but not on legal ID. And nothing, I don't know what else they're going to profit.
Judge, in her deposition, she identifies that one of the decedents as her son. Further, Judge, as your Honor is aware, Marcy's law allows the next of kin to remain in the courtroom during the proceedings.
Thank you.
Yes. Can I just?
I'm not trying to belabor this, but certainly I've not heard any inquiry from the state to the mother or the parents or any close relative if they know of any of his friends or any distant relative.
My experience suggests that more than half the times that this issue comes up, that there's a stipulation. I understand the defendant doesn't have to stipulate the identity of the alleged victims, but typically it's done by some agreement, parties stipulate to it. It wasn't done in this case, that's fine. You raised it earlier, and I said, that's fine, see if you can get somebody else. Counsel explained to me they made a good faith effort to get somebody else to be able to testify. That hasn't happened yet. There's a lull in the proceedings, and they want to move on and cross that T, dot the I, and have the alleged victims identified.
All right. I also want the case to move along, but quite candidly, they have not even inquired from the family about any distant relative, or I've not heard any proffer from them, or any friends of his that could come in.
I just heard her indicate 3 or 4 people that she...
Those were all state witnesses that they have not been able to locate for 4 or 5 since the inception of this case. They've all been implicated, and I would suggest to you that one of the problems they have is that they could be charged with a crime. I don't represent them. I don't profess to represent them. I have not met them. But the witnesses that they have spoken about are all individuals that were at the studio or in one of the cars.
What's your concern about a family member identifying a victim?
Well, I think the case law is clear. That's frowned upon because of the potential problem.
And what's the potential problem?
The emotional problem that would cause a mistrial. And we've now been in this...
Didn't counsel just, didn't I just indicate or ask the counsel to advise me if they've spoken with the family member who's going to identify, and they've indicated it, and they're going to do to whatever they can to minimize it. They're not even going to publish the picture at the same time, is the way I understood it.
Well,
right? So
yes.
I'm past the counsel respectfully. I understand your objection. I asked the state to see what they can do to get a different witness in. Apparent to me that they've tried. They're unsuccessful in that area. You think greater efforts need to be done. But we'll let the family member, again, is going to identify or indicate to the family that they're not to have any outburst of emotion or anything like that. And just we're going to move forward.
Understand you. The other component of the emotional and sympathy factor of relative testifying is the juror hearing the voice and seeing the family member and thinking and developing a sympathy and maybe feeling like they owe them. So there's, even if they don't become emotional, the risk of that happening does exist.
When they show autopsy photos and everything else, there's all types of, and the juries are explained to try to, you got to separate the emotion from it. It's part of the jury instruction that was given at the later time.
Just note,
Serious
we
case.
understand. We
Serious
understand.
case, and you know, it's certain pictures and certain things are emotional. And jurors are explained that in the instruction that they're not to let emotion play a role.
We understand the court's ruling, note our objection, and we certainly don't want to stand up and object of this testimony in front of the jury, because I think that draws more attention. So if the court will allow us to have an objection to this.
Do they have any objection to it? Standing objection?
No, you're not.
Just for the record, Your Honor, they might as well say they looked for Jimmy Hoffa, because they made no effort beyond what they already know, or they just came and voiced the name of people they haven't been able to find.
Like a tandem thing. I thought we talked about one attorney making the argument. It goes back and forth all the time.
Just want to make sure we have a complete record.
Well, then talk to yourselves about it beforehand, but one attorney making the case, she's arguing for the state on this issue. One of you should be able to argue the issue, not have both of you come back and one after the next, all right? I've ruled.
Thank you, sir.
Let's bring the jury in. Ladies and gentlemen, thank you. Trust you had a nice lunch. Let the record reflect the presence of our jury, the defendant, the defendants, the counsel, and the assistant state attorney. So I think you're going to publish.
Your Honor, we were going to call the witness at this time, Leon Phillips.
Phillips, please. Ms. Phillips. Welcome, come on up here, please. When you get to that chair, what I'd like to do is remain standing. Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your full legal name for the record.
Leon Phillips.
Please spell your first and last name for the court reporter.
Leon, Leonbra, Phillips, Phillips.
Thank you.
Please have a seat. Ms. Phillips, that microphone will go up or down, but doesn't move back and forth. All set? Counsel, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Phillips.
Hi, how are you?
Can you state your name, your full legal name for the jury?
I'm Leon Phillips.
Okay. And are you related to one of the decedents in this case?
Yes, I am.
How so?
I'm his mother.
And who is that?
Christopher Thomas.
And you have previously been shown outside the presence of the jury a photograph with ME number 18-3119. And that was a head photograph. It's now in evidence under States 75. And I believe it's photograph number 4. Who was that? Were you able to view that photograph?
That was my son.
If you recall, we showed it to you previously, the headshot with the medical examiner's number. Who was that in that photograph?
Christopher Thomas, my son.
Okay. And also,
Publishing States 7.
pause it at 2:19:15. Ms. Phillips, did you see who entered into the occupants who entered into that gray Jeep?
Mm-hmm.
And is that a yes?
Yes.
Do you recognize where your son entered that gray Jeep?
Yes.
Which seat, if you can identify for the jury?
He got in the back seat on the right-hand side.
Did you recognize the individual that got into the back seat on the left side, the rear driver's side?
Yes.
And who was that individual?
Jamell.
And Jamell, is that the defendant, Jamell Demons?
Yes, ma'am.
And do you know him by another name?
Melly.
And do you see Melly Jamell Demons in the courtroom?
Yes, I do.
And do you identify him by an article of clothing and where he's sitting in the courtroom?
He's sitting over there. He have a tuxedo. Gray, I think it was gray.
Okay. Your Honor, let the record reflect the identification of the defendant by this witness.
The record shall so reflect the in-court identification of the defendant.
Nothing further.
Ms. Phillips, we want to express our condolences to you.
Thank you.
Thank you.
Nothing further.
Thank you. You can step down. Thank you, ma'am.
I'm the state's going to publish 61, state 61.
Judge, can we approach?
To publish from state's table.
Yes, Councilman.
Sorry, one moment. Go ahead and approach.
Publishing photograph 1. Photograph 2. Publishing video 1.
He didn't do that. Ben I got to send people.
Publishing video 2. Video 3. Publishing now video 4. Publishing video 5. Publishing video 6.
Like, get right there, like, you know you come back.
Publishing video 7.
Come on, all that extra shit, like, they leave the most important shit here.
Publishing video 8.
Right,
Publishing video 9.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Publishing video 10. Publishing video 11. Publishing 12. Publishing 13. photograph. Another photograph. Third photograph in that series. Fourth photograph. Fifth photograph. Sixth photograph. Seventh photograph. Eighth photograph. Ninth photograph. 10th photograph. 11th photograph. 12th photograph. That's the end of state 61.
Just publishing now from State 64, the previously shown photographs to Defense Counsel. Photo 1. Oh, I'm sorry. State 64. Photograph 2. Photograph 3. Photograph 4. Photograph 5. Six. I'm sorry, 6. 7. 8. 13. 'I'm going to use the other computer. It works a little bit better with your just a momentary delay. 43. 44. 45. 46. 47. 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63. 64. 65. 66. 67. 68. 76. 77. 78. 79. 80. 81. 82. 83. 84. 85. 86. 87. 88. 89. 90. 91. 92. 93. 94. 95. 96. 97. 101. 102. 103. 104. 105. 106. 113. 114. 115. 116. 117. 118. 119. 120. 121. 122. 123. 124. 126. 127. 128. 129. 130. 131. 132. 133. 134. 135. 136. 137. 138. 139. 140. 141. 142. 143. 144. 145. 146. 147. 148. 152. 153. 154. 155. 156. 157. 158. 159. 160. 161. 162. 163. 164. 165. 166. 167. 168. 169. 170. 171. 172. 173. 174. 175. 176. 177. 178. 179. 180. 181. 182. 183. 184. 195. 196. 197. 198. 189. 190. 191. 192. 193. 194. 195. 196. 197. 198. 199. 200. 201. 202. 203. 204. 205. 206. 207. 208. 209. 210. 211. 212. 213. 214. 215. 216. 217. 218. 219. 220.
Thank you. Let the record reflect, I was just passing notes that one of our jurors needs a restroom break, so we'll take a short recess. Ladies and gentlemen, remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case. No research. Thank you. You can open that on your Thank you. Let the record reflect the jury stepped out. Councilor Manuel and defendants damaged the restroom break. All right, can you arrange that phone, please? We're recessed. Thank you.
There to be a minimum distance they were separated by.
Can you restate that?
Sure. The individual, whoever was in the rear passenger seat on the driver's side, and then Chris Thomas, who is in the rear passenger seat passenger side. Is there a minimum distance that they're separated by?
There is.
And how do you know that?
So we have a known distance. As I said earlier, we are confined to the inside of this vehicle. So we have a known distance of shoulder width inside the back seat of this vehicle. We know a distance of shoulder width of Mr. Thomas, and then we would be able to deduce the difference between the center console and another passenger.
So in terms of the photos at the Jeep when it first came to the hospital, are you aware of how the back center console was positioned?
Yeah, it was down just like that.
And showing from what's been previously admitted into evidence as states 30, photo DSC_0127. Is that important for your reconstruction?
Correct. So this is the blood that is on the center console is consistent with Mr. Thomas crumbling into the position above or onto the center console of the back seat. So this is a demonstrative photograph to show that you can fire a firearm from that position in the direction of a passenger who would be seated in that seat.
Okay. Now, looking from the other angle, what are you looking at in this photo, which for the record is 6717?
And that is just a forward picture from the front of the vehicle facing towards the back of the vehicle to show that it is still possible to fire a firearm inside the vehicle.
Okay. And then in terms of the measurement, how far away is the firearm from the face at that demonstrative photo, which is 6719?
In this particular demonstrative, it's approximately 6 inches.
Can you tell the ladies and gentlemen of the jury if Mr. Thomas was sitting straight up and didn't move to the side to get away from a gun?
At one point, I believe that he did.
And how do you know that?
Because Mr. Thomas has what's called a defensive wound on his right hand, and that defensive wound was caused by a projectile. So I believe that at some point he turned and put his hands up or attempted to de-escalate what was going on and received the firearm projectile through his thumb.
Okay, and so you're pointing to your right hand. In terms of the injuries to Mr. Thomas, do you recall which hand they are on?
I would have to look at the photograph.
Okay, we can come back to that in a moment on that. So the, and Ms. Smith is trying to get the any photos. The defensive wound. Why is that important for you as a shooting reconstructionist?
Because it lets me know that Mr. Thomas was not aware of what was going on. He was taken by surprise, and his hands being up. If his hands were down, he would not receive a projectile through his thumb. His hands are in an up position, almost saying, maybe don't shoot, or I relinquish or something, but he receives a defensive wound due to that projectile, and I think at that point he repositioned to be forward facing.
Were there any defensive wounds on Anthony Williams?
No.
So there is testimony that there was a driver in a car. Could the driver, Cortland Henry, have gotten that angular shot on Anthony Williams?
No.
Why not?
He would have to have a rather large arm. He'd have to be Inspector Gadget.
So in terms of, did you measure the height of Mr. Henry?
Yes.
And what was that height? Can you refer to your... report, please let me know.
He's 70.5 inches tall.
Okay. And in terms of his arm length, did you measure that?
No, I did not.
No. In terms of the height to his shoulder, did you measure that?
No.
So with regards to the length of his arm, why do you say he would have to have Inspector Gadget length arm to get that shot on Anthony Williams?
Because you would have to, it would be a very awkward position that his wrist is, no human wrist is simply capable of being in order to reach around, extend it out, and pull the trigger.
Okay. In terms of the intervening objects, how does that help you in saying where that firearm had to have been?
The firearm had to have been, would be due to the headliner being there. I'm sorry, the head rest being there. That all puts it all in line with the backseat driver passenger.
Okay. In terms of the angle for the driver to get the shot on Christopher Thomas, is that possible?
No.
Why not?
Because the injury to Christopher Thomas's cheek is an exact circle. And if Cortland Henry is pointing back from the driver's seat to the direction of the position of Christopher Thomas, you would expect to see a leading edge injury to his cheek instead of a perfectly circle on his cheek.
Okay.
On top of it, you would see more blood on the seat that Cortland Henry was sitting in for both. If he were to make both shots of those two individuals, there would be a substantial amount of blood on his seat.
Okay. Now, speaking about the rear passenger, can you tell the ladies and gentlemen of the jury or identify who was in that seat?
The rear passenger?
Yes.
Driver's side?
Yes.
I was advised that it was...
Objection, here's
So, without going into that, in terms of what you were advised, can you say, based on your own personal knowledge, who was sitting in that seat at the time of this homicide?
That would be Mr. Demens.
Okay. And how can you say that?
Can we approach?
Sure.
So, Mr. Williams was not even aware he was about to be shot. When Mr. Williams was shot, Mr. Thomas puts up his hands and is shot, and then is shot again.
Okay.
There's no time for anybody to switch a firearm. If there were, I believe one of those individuals would be alive. There's no time to switch. It was a very, a rather rapid event of firing.
Okay. Can you say the length of time between the fatal shots and then the staged drive-by shots later on?
It was enough time for the heart.
It's 66 degrees in here, and it's quarter 13 of 3. I just wanted to report that to the court. Because I'm ready to borrow the jacket of one of these nice BSO officers.
You all set? Ready to go?
Yes, sir.
How about steak?
Yes, sir.
Can you see if the jury's ready?
That's good.
Feels colder than 66.
That's what Gary said.
Keep dropping. Jury ready?
Yes, sir.
All right, let's bring him in. Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our defendant, the counsel, the assistant state attorney, ladies and gentlemen of the jury. Ladies and gentlemen, I think the statements missed in this publication of certain photographs. What exhibit number is this again, counsel?
64, the extraction of the 98 of Southern Phone.
Thank you. You ready? You may proceed.
$240.
262. 263. 264. 265. 266. 267. 268. 269. 270. 271. 272. 273. 274. 275. 276. 277. 278. 279. 280. 281. 282. 283. 284. 285. 286. 287. 288. 289. 290. 291. 292.
339. 310. 311. 12. 13. 15. 316. 317. 318. 319. 320. 321. 324. 325. 326. 327. 328. 329. 330. 331. 332. 333. 334. 335. 336. 337. 338. 339. 340. 341. 342. 343. 344. 345. 346. 347. 348. 349. 350. 351. 352. 353. 354. 355. 356. 357. 358. 360. 359. 361. 362. 363. 364. 365. 366. 367. 368. 369. 370. 371. 372. 373. 374. 375. 377. 378. 379. 380. 381. 382. 383. 384. 385. 386. 387. 388. 389. 390. 391. 392. 393. 415. 417. 418. 419. 420. 421. 422. 423. 424. 425. 426. 427. 428. 429. 430. 431. 432. 433. 434. 435. 436. 437. 438. 439. 440. 441. 442. 443. 444. 445. 446. 447. 448. 449. 450. 451. 452. 453. 457. 458. 459. 460. 461. 462. 463. 464. 465. 466. 467. 468. 469. 470. 471. 472. 473. 474. 475. 476. 477. 478. 479. 480. 41. 42. 43. 44. 45. 46. 47. 48. 9. 490. 481. 492. 493. 525. 426. 427. 428. 429. 500. 501. 502. 503. 504. 506. 507. 508. 509. 510. 511. 512. 513. 514. 515. 516. 17. 518. 519. 520. 521. 522. 523. 524. 525. 526. 527. 528. 529. That would conclude the publication of the selected photos from 772, 713, and 807 calls.
Thank you.
Karen, you consulting schedule?
Sure.
Maybe we should take a break. Just give it.
Need a break?
Fine. Please.
Watch one side first.
Caused deaths. That was a tremendous leap of faith. It was too attenuated, and the jury
Do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, and certainly no research. Also, ladies and gentlemen, just remember that next week is the 4th of July week, and the courthouse is closed one of the days, but we had indicated because of issues with witnesses that we were going to break and wouldn't return until the 10th. So July 10th is the next scheduled date we're going to be in. We're not going to be in session next week. All right, so we'll see you all back on, that's July 10th, that's Monday at 9 a.m. All right? Thank you, ladies and gentlemen. Have a nice morning. You can open these on your chairs. Thank you. Let the record reflect the jury step down. Counsel remain along with the defendant. So you said there's more that you have to publish to the jury?
Yes, there's the videos on the 9807 phone. The defense counsel needs to go over and I have to show them exactly which ones, and we have to go through those, and then we'll have to read.
How long are the videos?
There's tons of them, Your Honor. So I have to prove it's the defendant's phone.
Thank you. So how are we going to handle this? You want to, have you seen the videos? I take it. I mean, you have them. They're set over discovery, correct?
Yes,
Well, they're now isolating those that they intend to, and we'll make sure that we do what we need to do during the time limit. I don't think we need the court's intervention.
Well, this is my thought. If there's an issue about it, I don't want to have a problem with it. My thought is, if there is an issue about it, we'll resolve it and we'll do it on some date next week when we're off. We just pick a date that everybody's good for, and we'll resolve it during that week if there's a problem.
Makes good sense to me, sir.
What time do we have Friday? Have Friday issue? Any issues Friday? I know we have hearings.
In terms of the 6th, I believe I scheduled the depot for their defense witness.
I wanted to ask you about that too, but let me hold on. I just want to find out, make sure we need time on that Friday. That is the 14th, I guess.
The 7th, Your Honor.
Next week, Friday.
Yeah, the 7th.
It's the 7th. I apologize. I'm looking on the week of the 10th. You're right.
7th is fine for the statement.
So could we clarify, because we were supposed to get a date today for the deposition, and now she's saying she's scheduled the 6th?
No, we're talking about the 7th.
We're going to get the depositions of the 7th.
Okay.
So, counsel, on the 7th, everybody's available on the 7th if we need it? So how much time do you think you need?
I have a 1 o'clock afternoon in the afternoon in 7th federal court, so something in the morning, and also I would need to be here if everybody else is.
So, how much time do you think you need?
I don't know if we'll even need anything, or if we're fine on that, so.
So why don't we just plan on it? If you need it, we'll do it at 11 o'clock.
Sure.
That'll give you an hour. Is that all right? Does that work for you?
Yes, sir.
All right, so we'll do it at 11. That's good for everybody, yes?
Yes, sir, that's right.
All right, on the 7th, and what I'm going to ask you to do is contact my office beforehand and just tell me, you know, if you need the time or you don't need the time, all right?
Thank you,
Yes.
Now, what about the depositions? First, yesterday, I think, when Ms. Smith indicated to me there was a witness that stated, or I guess you did, Ms. Bradley, objected to the scheduling of the deposition without your knowledge and consultation beforehand. And Ms. Smith indicated she didn't believe the witness was going to show anyway because you would have been trying to get the witness to come. And he didn't. Is that deposition, what's the witness's name?
Crazy on glass, sir.
And that witness looks like it's going forward, the deposition?
His sister called our office to ask if it was Zoom or if it was in person, and she was told that it is in person.
All right, so assuming this witness's deposition is taken, when is it set for?
Tomorrow morning, Your Honor. So Judge Siegel has been kind enough to move my hearings around. So for that, for Mr. Smith's case, so I should be available.
So everything's good?
Yes.
All right. Was there another deposition?
Yes, Judge. She had stated that she's having our witness depose.
Who was your witness again?
That would be Larry Daniel. Thank you.
Yes. I was told yesterday to pick a date and they would make him available.
That's the cell phone witness?
Correct. And so the first date I'm available next week is Thursday, the 6th.
They're good?
I will check with him, but this is the one that she wants him in person, and per the rules, 92.142, she needs to be providing his airplane ticket and his hotel.
Well, the court reporter is going to appear via Zoom, so I'll do it via Zoom on that. That's not a problem.
Okay, thank you. I'll speak to Larry, make sure he's clear, but I did tell him yesterday that it would be next week, so I'll confirm that and I'll let her know this evening. But it shouldn't be a problem.
And Your Honor, I filed a motion to compel any of the materials for Mr. Daniel that he has done. Nothing's been provided other than a CD. So if he's relying on any demonstratives, anything else like that, that would need to be provided to the state forthwith.
Did you give a report?
We did not give a report. We were fine with the FBI, and again, I had reminded the court she had given me case law last week, which now requires me to bring my expert. He is doing tests. If I get a report or any of the results back from the testing of these tools that he's using, I will definitely give it to her prior to him coming. I'll give it to her upon me receiving it.
My question was, do you know if he has a report as of yet?
Nothing as of yet, Judge.
So I'm hearing something about testing being done and things of that nature. So if anything is going to be done, it needs to be done and turned over, I would say, prior to the deposition, because they can't ask about something that hasn't happened.
I agree with you. Like you said, the minute I have something, if something is prepared, I will provide it for him.
Well, I guess the concern Ms. Bradley has is that if there's not a report turned over to her, and when she's walking into the deposition the first time that's handed to her, she's at a loss of a disadvantage is what I think she's trying to convey to me.
I promise I will not ambush the state, Judge. So as soon as I have something, if there's something created, I will give it to her within minutes of me receiving it. There's nothing else I can do about it. She wants to compile something that doesn't exist at this point.
So, Your Honor, my concern is it sounds like the expert was going to do some sort of testing once he gets here. That was how I took Ms. Liberty's last statement. So in that instance, what's the purpose of doing a deposition? If he's going to be creating new information or new reports as he's testifying. So I guess that's...
I don't know that that's what the intent was. I thought that was a generic statement as to what the witness may be. I don't know. There's no report now. You want to take his deposition. Obviously, if there's some, he makes a report or does some testing and it's not turned over to you, you don't know about it, and he's not explaining anything in the deposition, and you want a new report, new evidence, that's the Richardson violation. If you were saying there's a discovery violation, we talk about it, and you have a right, I would think, to cure whatever problem there is and redepose the witness, or if that happens, we'll make some accommodation. I mean, I would think that'd be appropriate.
I agree, Judge.
So So let's just take it one step at a time. Council suggested she's going to turn over whatever she has as soon as she gets it, and I accept her representation. She also, Ms. Liberty also indicated that she was going to reach out to the witness, correct? You said to find out whether there's something's forthcoming. So we'll take that one step at a time, but I understand your concern. You don't want to be ambushed or sandbagged with the report and start asking questions and you haven't seen the report yet. So let me know.
And so the other concern then becomes a potential Daubert issue. If he's doing some new testing or something like that, so that would have to be raised. If it's not been provided, I can't file a timely Daubert objection if I don't have the information. So just want to make sure that's clear for the record, and I'm aware of that issue as well.
Let's cross the bridges as they approach.
I don't know what the issue is with the witness. You're saying the witness was never disclosed?
No, Your Honor. What happened was the witness was listed in, 2022. And if I'll pull up the email so I'm quoting exactly, I had his deposition scheduled for March of...
Just to move them on, we were not going to call him because the FBI...
So you had him on the list, counsel scheduled for deposition, then you withdrew him as a witness?
Yes.
This is that witness, all right.
Okay, and then last week she gave us a case from Wisconsin on the Fitbit and the lay person. So I started researching the Fitbit and all the case law that goes with it. So at that point, based on her providing this case law that she's relying on, I now have to get the expert to test the Fitbit and the health app on the iPhone. So once I have those done, because she's going to go back to that motion, we'll talk about the motion to come. I will guarantee the minute I have some type of proof, if he gives it to us, it will be provided to her. But that is the issue. She told us last week, this is what she's relying on, and we have to prepare for it.
So in terms of, he's no longer a cell tower expert as previously listed. So that's what I was prepared to depose him on, was he was listed as a cell tower expert, and he was deleted as such in...
And now we're trying to list him as a Fitbit expert?
What she's going to, based on the case law she provided last week, yes, Judge.
So on Monday, March 20, 2022, Ms. Liberty emailed myself, Mr. Adelstein, Mr. Howard, and Mr. Haddad, saying we will not be using Larry Daniels for the cell towers. We will remove him from our witness list. Thus, there is no need for the depositions tomorrow.
Well, counsel suggested she did that. She said she withdrew as a witness.
Correct. So just so that it's clear on the record as to why the deposition wasn't done prior to the start of trial. So she has not yet listed him as an expert in new areas on that. So that would not be a Richardson violation in terms of that. So I would just ask if there can be some sort of proper as to exactly what he's testing or what he's doing on this particular item so that I could actually be prepared as opposed to going and thinking of doing a cell tower deposition next week.
So it's not about cell towers, correct? It's about Fitbit.
Yes, based upon Ms. Bradley's, the state attorney providing me certain case law is very specific to what she provided me. So he's going here and saying she's not sure what, I'm making it very clear. That case is what we need an expert for.
I'm not familiar with the case, but let's take the case aside. This expert you have is in response. You're saying you're listing a new witness. You're listing him again only as an expert this time as the Fitbit.
Well, we'll use the word Cellbrite because she's going to get the health data off of the Cellbrite download. So we'll just call her Cellbrite expert. I think that would cover everything, and she knows exactly what she needs to be preparing for the Cellbrite, and she is certified Cellbrite expert, and that is on the CV that was provided for her, so that should be no surprise.
I guess you don't have a report yet.
There is no report in existence as I stand here.
You don't know if you're getting one.
Exactly.
And so counsel's asking for a proffer as to what you believe this witness is going to testify to.
celebrate.
Anything more than that?
No, it will be celebrated.
And when you say celebrate, what do you mean celebrate?
So we just set 2 hours of her data, that's all from Celebrate. So
Understood.
she's going to try to.
Well, what's his opinion going to be? Maybe that's the better way to do it.
So his opinion will be on the reliability of the health data app that's on the iPhone X, which is the model of phone. I believe she's done that data down the line.
So that's what he's going to share opinion on. That's what you retain him to do, render opinion in this area.
Exactly, Judge, yes.
Okay. So that gives you a little bit of heads up.
Okay, thank you, Your Honor.
And we'll see where it goes, and we'll take it one step at a time.
Okay, thanks, Judge.
Anything else to discuss?
Yes.
You're a wonderful board.
Oh, by the way, thank you, but this motion, you filed this motion about a jury view? Is that right?
Yes, Your Honor. So I was trying to see if we could take defense counsel down to look at the vehicle, but it's my understanding they've put it back into storage.
It's not there anymore?
Nope, that was what Sergeant Colliard with the Broward Sheriff's Office Crime Lab told me when I asked about that on a break.
So is this jury view item moot now? Not going forward with it?
Well, not for today. At this
For
point.
any day?
So no, we could do this at another date when we return.
So the date I gave you for the hearing, just plan on being there. We'll argue whatever motions there are. If this motion's pending, we'll argue the motion.
Yes,
all right. Regarding the jury view on that Friday, 7. Okay.
Maybe we
11.
can take a